ಸುತ್ತಿರುವ ಬೆದರಿ Sarvebhyo Namaha. A warm welcome to everyone to this 3-day lecture series on a very important topic, religion and law in India. To deliver these lectures, we have amidst us Sri Kashyap and Naik. Now, people who are here will very well remember the absorbing set of lectures that Kashyap delivered not too long ago. One on the eminent, the great Nani Phalkiwala, and the other on Indian Constitution, how it has evolved in independent India, and the kind of repercussions and consequences that we have faced as a result of various constitutional amendments and the laws that have been instituted and things like that. Those talks were very well received by people, and they were even parts of discussions in various quarters. In continuation to it, Kashyap has agreed to talk on various topics in times to come as well, and it is one of the objectives of the Gokhale Institute to have such talks on various subjects that concern the public at large. This time around, Sri Kashyap Naik is talking to us about religion and law in India, like I said. Now, the dictates of law, as all of us know, have a bearing on almost all aspects of life, and since religion is so significant a part of all of our people, that too comes under the ambit of law. And we all know that in our state and elsewhere in India as well, issues such as whether to keep one kind of nama or the other kind of nama concerning the Sri Vaishnavas, issues like this get dragged to the court. Concerning the Nava Vrindavana, all these issues, right till the recent issue that we faced concerning the hijab, these things get dragged into court. So it is very important for us to analyze these issues very objectively in the light of the constitution, and not to speak about the inclusion of the word secular in our constitution and the various repercussions that it has led to. Kashyap is eminently suited to talk about this topic, not just because he is an advocate. He is a much sought after advocate in Bangalore. He is a co-founder of Agra Legal, which works primarily out of Bangalore, but also in several other states of India. He is also an ardent student of the Indian way of looking at these things. He has studied the monumental history of Dharma Shastra by P.V. Kane. He is also an ardent student of the Artha Shastra. He knows music. He has learnt Hindustani classical music, and he is himself an exponent of Sugama Sangeeta. He is trained under Sri Shankara Shanbhag, and he is also a publisher. He works with an organization called Praharsha Publications. So it is not just modern law and its various manifestations that Kashyap is familiar with, but also the Indian way of looking at things. We are very privileged to have such a learned speaker who represents the best of both the East and West, to have agreed to talk to us about such an important topic. I now request Kashyap to please begin today's proceedings. On behalf of all our speakers and the institution, I extend a very warm welcome to him. Thank you.
Om Tat Sat. Good evening, everyone. I deem it my privilege to be speaking once again in Gokhale Institute of Public Affairs on a very, very important subject called religion and law in India. It is both important and controversial. I think every one of us to ourselves would have had several opinions on what religion is, and every one of us would have also formed an opinion on how law should treat a religion, or vice versa on how religion should be treating secular aspects of law. Now, even before I begin to talk on this subject and deliver the 3-day lecture here, there is a certain disclaimer that I would have to give. The disclaimer is that whenever anybody speaks on the aspects of religion, there is to some extent an inherent bias, or there is an inherent tendency of our own culture in which we have been brought up with when we address the issue of religion. There was a great American jurist who also happened to be a judge of the Supreme Court of US, Justice Benjamin Cardozo. when he was speaking about the nature of judicial process, that is how judges write their judgments, said these very important words while talking about how judges form their opinion. As we all know, judges are supposed to be very impartial. They are supposed to be unbiased. They are supposed to be extremely objective, for it affects the lives of several people. I may say something very biased in this lecture series, it won't affect anyone. But if in case a judge, while writing the judgment, has certain bias or impartiality, it affects everybody, or at least the parties to that particular case. While thus thinking about the very nature of judicial process, Justice Benjamin Cardozo said, there is in each of us a stream of tendency, whether you call to choose it philosophy or not, which gives coherence and direction to our thought and action. Judges cannot escape that current any more than mortals. All their lives, forces which they do not recognize and cannot name have been tugging at them. It can be inherent instincts, their traditional beliefs, acquired convictions, and the resultant is an outlook on life, the conception of the social needs, a sense, in James' phrase, of the total push and pressure of the cosmos, which, when reasons are nicely balanced, must determine where choices shall fall. In this mental background, every problem finds its setting. We may try to see things as objectively as we may please. Nonetheless, we cannot see them except the eyes of our own. To that test, they are all brought before a judge. What? It can be a form of pleading or an act of parliament, the wrongs of paupers or the rights of princes, a village ordinance or a nation's charter. So, if one of the best judges the world ever saw had to say that anybody who has to be howsoever objective will have to be looking at his own eyes, which itself may be tucked with several tendencies which you would have taken by virtue of his convictions, I don't think I can say that I'll be very, very objective and unbiased. My own cultural upbringing, the region in which I have been placed, I have been brought up, howsoever objectively I may present, it may have a certain amount of bias, to which even before I begin the lecture, I would like to say, kindly excuse me if in case any of these biases try to come in the midst of an objective analysis of religion and law. When I say this, I am not an exception, I am the rule. Not just me, every one of you, every one of us who have been as objectively as we may please will also stand in the same footing. I haven't seen a more learned and complete scholar like Dr. P.V. Kane. Even Dr. P.V. Kane, in his History of Dharmashastra, says, I belong to Chitpavana Brahmin community, I am from Maharashtra, and with this upbringing, there may be certain biases. If a scholar like P.V. Kane has to admit it, who is Kashyap Naik to say I don't have? So with that disclaimer, I would like to begin my lecture on religion and law in India. Now, we will start with the very basis of what is religion, what do you mean by religion, how it is defined, what is law, what are the interconnections between the two. In my 3-day lecture, I will be making the lecture into 3 parts. I am restricting the subject of religion law only to the Indian context. Wherever the subject demands, I may draw inferences of political and other legal happenings that would have happened outside of India, but my focus is on India. And when we say India, we all know that it's a very, very, very old and timeless country. We have had history of several thousands of centuries, and at least from the literary sources of Dharmashastras itself, we would have to examine approximately about 2.5 to 3,000 years when we talk about law. The law, as we all know today, which is legislature made by the parliament, is only about a century or so old. Before that, there have been treatises of Dharmashastra which are followed by people all throughout. I would be incomplete if I do not touch on these various and aghast volumes of Dharmashastras and the way it dealt with religion and various other tenets of other religions which have flowed into India and the way they treated other religions. So therefore, my first day of the topic would be about law and religion up till almost the 20th, half of this 20th century, until either say partition or the independence that we got. tomorrow I would be speaking about from the time of independence until almost the end of the 20th century. And on the last day, I would be speaking about the trends, the current religious and legal trends, the way it has been applied in the courts, some of the present cases that have been going on, and what is its criticism and also the future. All these would be discussed on the last day, and certain conclusions and inferences and various opinions of the authors would also be quoted on the last day. So I begin my lecture with the definitions as well as how the subject was treated from almost say the Vedic period. The Encyclopedia Britannica defines religion as the human being's relation to that which they regard as holy, sacred, absolute, spiritual, divine, or worthy of special reverence. It also commonly regarded as consisting of the way people deal with ultimate concerns about their lives and their fate after death. They say that in many traditions, this relation and these concerns are expressed in terms of one's relation with or attitude towards gods and spirits. Now, when we say only about gods and spirits, it includes both pagan and Semitic religions. Then comes only what they call as the pagan religion or the Sanatana Dharma. In more humanistic and naturalistic forms of religion, like say Hinduism, they are expressed in terms of one's relationship with or attitudes towards the broader human community or the natural world. That is to us what is religion. In many other religion, mostly the Semitic ones, texts are deemed to have the scriptural status, and people are esteemed to be invested with spiritual and moral authority to speak about those texts. So where you have texts and prophets, and they alone are the guiding factors of a religion, that is also religion. Where you speak about broader human community and the natural world and the way you want to deal with it, that is also religion. So religion is a wide compass. Now, in India, religion is mostly equated with the word dharma. There have been several scholars who have opined that the word or the term dharma and religion are not synonymous to each other. Religion can be a small part of dharma, but dharma itself is much wider to encompass. The definition of dharma, as we may see, is sustenance, that which sustains, that which upholds, that which nourishes, that which supports you for your very living is called as dharma. Now, if this is dharma and religion, what is law? Law has a very, very simple meaning or a definition. Law is nothing but a bundle of common sense. This bundle of common sense is something that we have been taught in our very first year of legal studies. Students who come to college learn that law is nothing but a bundle of common sense. That means to say that whenever you see things very, very objectively and you think that this should be treated in this particular way, most likely the law is going to be that. Even many of the lawyers, we cannot say that we know every other law that has been passed, every legislation framed by the parliament. Many of our seniors have also taught us, when you argue and if you don't know a particular law, speak with common sense, some law will support you. That is the reason we say law is nothing but a bundle of common sense. Now, why is there a friction between law and religion, if we may ask? If religion is also to be understood as something which is sustaining you, or which is nourishing you, or which is leading you to the way of life, I don't think there would be too much of a difference between religion and law. But if religion asks you to blindly obey something just because it is said in a particular text, now it forms it forms as a faith. It can be a blind belief, or it can be your assertion, what we call as shraddha. Our faith is in something. We may not have specific reasons. As they say, heart decides, head reasons. We may emotionally be attached to a particular faith or to a particular belief, and we may try to reason it objectively as we may please. But nevertheless, the faith is completely different. It cannot objectively apply to everyone. Now, this Sanatana Dharma, when we speak in India, the way it was, even the before Christ period, the earliest scriptures on this Dharma Sutras have been, say, Manusmritis, various other Smritis were there. The very sources of these Dharma Shastras or Dharma Sutras were Vedas, Smritis, and several customs. These ultimately formed the Ashtadasha Vidyasthana. When we see, there is an important place given to Kalpa Sutras. Dharma Sutras or Dharma Shastras are carved out of the Kalpa Sutras. Now, until and unless other religions actually put its foot in India, we did not know that there were several other religions. We only had several schools of thought. So, therefore, we had several branches of philosophy. Now, mainly there are two branches of philosophy, which is homogeneous and heterogeneous. Homogeneous philosophy is our Shaddarshana, Sankhya, Yoga, Nyaya, Mimamsa, Vedanta, Vaisheshika, all of these yoga, they are all Shaddarshanas. They are called as homogeneous. They base their schools of thought on the Vedas. That's why it's called as homogeneous. Heterogeneous are Buddhism, Jainism, and Charvaka. All of these put together are called as Indian philosophy. Until the advent of Islam, there were only schools of thought. There was Jainism earlier, there was Buddhism earlier, there were certain rebels also earlier. But all the schools of thought had very clearly assimilated with the way of life of Hindus. So, until about 9th, 10th century AD, or a small skirmish that occurred in about 7th century AD, we don't really see there being civilizational clashes in India as part of religious frictions. There have been heated arguments, there have been exchange of thoughts, there have been building of temples, there have been faiths trying to bully over each other in respect to twisting the Puranas. You had several divides. For example, Buddhism also started several other sculptures in a way to put down. If any of you may read Dr. S.L. Bhairappa's Sartha, you would know as to several advents made by these Buddhist tapatis in respect to these temples. If your Ganapati is having one elephant head, our Ganapati will have about 5 elephant head. If your Shiva can have a Raudra in a way in which he is very fierce, we will make a god which is even more fierce. And even in our own Hinduism, we had Narasimha and Sharabha. Some of our friends, we recently visited Tamil Nadu and we see that Sharabha was a god of Shaivite school who said that the Narasimha became very, very powerful, and in order to subdue him, Sharabha's avatara was taken. And then there is Pratyangiri, so on and so forth, it continues. So, although in these particular faiths, there have been exchange of thoughts and also a inner zest in order to dominate the other faith by virtue of several of these artistic expressions, as also the Puranas or the scriptures. But in the regular way of life, the life of a common man, they did not find any difficulty in leading their life. They had all assimilated into one single large unit. Now look at some of the rulers who had also changed their faiths. We had seen several rulers who had converted to Buddhism. Sometimes we also see the king practicing a particular faith, the wife following another faith, the kids follow some other faith, but all part of the same kingdom or the same Rajavamsha. Now these changes, although were there, it did not result in anarchy. It did not result in forceful conversion. You did not see it, only it was a spread of idea, and that particular idea as and how it spread, it would have appealed to many people, and out of that appeal some would have converted, some would have reconverted back, and some would have stayed in that particular aspect or that particular faith. When we saw about this branch of philosophy as the way it was being developed, none of these branches of philosophy, either homogeneous or heterogeneous, had any aspects of law relating to transactions, property, crimes, punishments to certain crimes. All of these, you don't find it in the philosophy when you read Sankhya or Buddhism, Jainism in detail. There may be references, I don't deny, but it was not meant to define and speak on these aspects alone. They mostly dealt with the purpose and objective of life. They dealt with the very existence of human life and life after death, all of these. But there was a separate segment called as Dharma Shastras. Now when we see Dharma Shastras, it had two wings, one for Achara and another for Vyavahara. Achara is ritualistic and Vyavahara is business or transaction. The way law as to how it should apply and treat transactions was called as Vyavahara. Then, when we see the sources of some of these Dharma Shastras, we see there were several Dharma Shastrakaras right from the beginning who have written several Dharma Shastras. Kane gives a great account in his very first volume of the several Dharma Shastrakaras who had come. So, coming from the beginning until later, we saw Bauddhayana, Apastamba, Kautilya's Arthashastra, Atri, Ushanas, that is Shukra, Kashyapa, Brihaspati, Manusmriti, Yajnavalkya Smriti, Parashara Smriti, Narada Smriti, Pulastya, Prajapati, Vishwarupa, Shrikara, and Medhatithi. All of these until about 9th century or 10th century, we saw many of them write several Dharma Shastras. Now, these Dharma Shastras were written by learned scholars or learned Brahmanas who are attached to a particular king's court. Then, were these Dharma Shastras alone the only sources of law at that point of time? Achara also dealt with the way how a ritual had to be made. Achara dealt with several aspects on, including, say, for example, marriage, your upanayana, about your learning, if a particular sin is committed, how to do prayaschitta, and shaucha, ashaucha, all of these are all written in achara. Achara means the way of living, as to how it is prescriptive in nature to say if you live this particular way, it would do well to you. Your life would be better. All of these, some of these aspects, and in order to maintain discipline, many of these were written in the form of achara. Now, Vyavahara, when we look into the chapter of Vyavahara, you have several contracts as to how one would enter into a contract with the other. What are the types of evidences one would have to give? What should be documented? And should a transaction take place in the day or in the night? Why night transactions are illegal? And even in Vyavahara, there were two segments. One which is civil in nature and one which is criminal in nature. And even in what is civil in nature, there were 18 titles of law that Kautilya lists in his Arthashastra. As I told you about nature of contract, he also speaks about marriage. And Kautilya perhaps was the first person to even speak of judicial separation in marriage, what today we recognize as divorce. And duties of a king, what he is supposed to do. And the political administration, what we today call as administrative law, were also part of the chapter of Vyavahara. And how a petition should be presented before the court, what should be the contents of a plaint, what should be the contents of a written statement, how many evidences should come, how a judge should deal with a particular subject. All of these were written in greater detail in Dharma Shastras and Artha Shastra. What is the difference between Dharma Shastra and Artha Shastra? The treatment of the subject is what it differs. While Artha Shastra places the importance on the financial aspects, that is Artha, and also on the land. Artha is not only on the property or on the money, but it is also on the land. Land is also a wealth, an asset on that, and on the way in which political administration will have to be looked into. Dharma Shastra was more on the what is the right, what is to be carried on it, apart from the only aspects of Vyavahara. Lot of other aspects including Achara also had to come. For example, in Kautilya's Arthashastra, we don't see any aspects of Achara in it. All of these, when it comes, it also makes part of Dharma Shastra. Now, there are several sources. Kindly look at in Arthashastra, Kautilya says that in virtues of his power, that is the king's power, to uphold the observance of the respective duties of the four castes and of the four divisions of religious life, and in virtue of his power to guard against the violation of the dharmas, the king is the fountain of justice. Chaturvarnashramasya lokasya achara rakshanat nashyatam sarva dharmanam rajadharma pravartakaha. So, apart from saying what is the rights of a king, this also says what is his bounden duty. He should ensure that there is no violation of dharma, and therefore you are therefore the fountainhead of justice. And while talking about in the manner in which he is supposed to dispense, there are four aspects which he says. One is sacred law, dharmascha, vyavaharascha, charitram, rajashasanam, vivadarthascha, chatushpadaha, paschimah purvabadakaha. Sacred law, that is dharma shastras, evidence in vyavahara as to uh, you have the weight of evidence in each of the cases. Then charitra, that is precedent, how earlier kings or earlier cases have been dealt with, and what is the itihasa in this, that one. And then rajashasana, edicts of the king. These are the four legs of law under which the rule of law will have to be there. And in these four, the order is in the reverse. Why? Rajashasana is practically to the very effect. Suppose there is a COVID kind of a situation, there is a pandemic. Some important aspects, some important decisions will have to be taken today in order to curb that particular pandemic. I would say wear mask, don't go here. You can't find this in the legislation, because nobody would have thought and legislated this. So also the Dharma Shastras. So therefore Rajasasanas are practically like government orders being issued for a very, very particular aspect. So you will have to give that importance first. Then before that, you will go to precedent. We have, even now we have law of precedents even recognized under the constitution under article 152. Suppose a Supreme Court judgment says a particular thing, High Court cannot divulge from it. It has to follow what the Supreme Court says. Supreme Court itself will have to follow one of its earlier judgments and have to write. This is called as law of precedents. So he is saying that the king should follow this law of precedent. He cannot say in every case I will go according to my whims and fancies. So law of precedents. Then says, look at the very evidence that is there, which is regulating the parties. Look at the weight of evidence, because facts are important. Law, when it is being made, is always made in vacuum. When a law is legislated, the legislators would not know as to what kind of cases may come up by virtue of these cases. It is only when two parties, when they try to transact under that particular law, disputes arise. Evidences come in. So therefore it is important that what is the evidence in this case before looking into just what the law is. So therefore he says, give tertiary importance to that. And importantly, the main dharma that is there, dharma shastra that is there, you will have to give it to it. And within the four corners, you have to make an harmonious interpretation and give a judgment. That is what Kautilya says. Now when we look into this is extremely secular, and even to this day what we follow is more or less what has been said in Arthashastra. Then further he goes on to say, whenever there is a disagreement between history and sacred law, or between evidence and sacred law, then the matter shall be settled in accordance with sacred law. That is a particular, what even now we call, there is a concept called as per in curiam. If a particular judgment is written in ignorance of a particular law, poor judge did not know that a law existed, he wrote such judgment. The next judge does not have to follow it, because he says, even though there was a particular precedent to me, he has not looked into a particular legal aspect or a particular law which is important, so therefore I have to go by it. So therefore whenever there is a dispute between the very sacred law and the precedent, sacred law is what it remains. So statute, importance of statute is what he says. But whenever sacred law, that is Shastra, is in conflict with rational law, this is where Kautilya's importance is to be seen. This is not, this kind of sentences you don't find it in any other Dharmashastra. Whenever sacred law or even the Shastras is in conflict with rational law, that is Dharmanyaya, that is the king's law, then reason shall be held authoritative. For there the original text is not available. He says when a Dharma Shastra is written, what is the basis of his reasoning to write that particular Dharma Shastra was, we don't have it. Manu Smriti, why Manu wrote this, we don't know. We may sit and comment today, criticize today. What was the aspects due to which Manu wrote that particular Smriti or a particular clause in that Manu Smriti or in Yajnavalkya Smriti is not available for us to see. So whenever there is a conflict, go by your rational sense and by judgment and you write. That is what Arthashastra says. Now, after several other Dharma Shastras that I told you already, Baudhana, Apastamba and Triyushanas, etc., also dealt with several aspects of both Achara as well as Vyavahara. Some, for example, Medhatiti work, that is Vigneshwara's Medhatiti, Vigneshwara's Mitakshara law, or Vignaneshwara's Mitakshara law, or Jimut Vahana's Dayabhaga law, mainly concentrated on aspects of law of inheritance, on aspects of property, rights of a particular family. All of these were given much importance. Whereas if you look at some other Bauddhayana or Apastamba, etc., more importance is given to Achara's aspects. So on different subjects, we have different Dharma Shastrakaras who have laid personal importance because maybe perhaps they were more learned in that particular branch of Dharma Shastra. Dharma Shastra itself is a great ocean, and it is very difficult for one to comprehend what all aspects of Dharma Shastras could be covered. And I think India would have to be greatly indebted to Dr. P.V. Karne because of that one man. We have a very, very critical analysis of all the Dharma Shastras which were available in India until that particular point of time. And anyway, then by the end of 9th century, the way in which these particular laws were being made on aspects of religion also. Now, before Islamic invention, when I take into it, I will have to speak on some of the duties that this Dharma Shastra laid on kings. I will not be specific to a particular Dharma Shastra, there are many, but out of all these Dharma Shastras, they were common in saying that it is the king's duty to rule the subjects very, very properly and in a very, very fair manner. If a particular king is not ruling the subjects in a very, very fair manner, if he is a very unjust king, the subjects had the right to throw away that particular king and in his place put another king. The modes differed from Dharma Shastras to Dharma Shastras. Some would say that this is the particular way in which you would adopt various categories under which a king would have to be made. If that king is useless, look at the prince. If he is useful, crown him as the king. If that entire branch of the family is very bad, please go to the nephew of that particular king. In his paternal side, adorn him as the king, crown him as the king. If none of them are there, go to the kinsmen and see who is more better and crown him as the king. Suppose there is no other person under the king's family, royal family, see a very, very virtuous Kshatriya who would be able to rule the land and appoint him as the king. And there are also simple things like where you give the garland to a particular royal elephant and it would go and garland somebody and they would be made as the king. So starting from a mere gamble to complete objective analysis, we have several manner in which a king would have to be appointed. It can be both democratic or it can be in a way of inheritance. And our line has followed. And every one of them, irrespective of the way in the king who has to be appointed, lays special emphasis on the fact that subjects would have to be ruled very, very judiciously. There should be no injustice. There should be no corruption in the administration. And what should be the punishment for such corruption or malpractice in the administration or mismanagement of the kingdom? All of this has been dealt in great detail in several Dharma Shastras and also in Kautilya's Arthashastra. Now, for a country which has gone by these scriptures and have had led its particular life in this particular way for roughly about 6,000-7,000 centuries, were completely unaware of some of the external influences some of the Semitic religions would bring. The two kinds of religion that mostly the West differentiates are one are Semitic religions, another is pagan religion. Now, pagan is a word given by the West. It is a denigrative word. It is wrong on our part to say we are pagans. It is very, very denigrative for us. For them, Semitic religions are mostly Christian and Islamic religion and Judaism. These are Semitic religions. What they call as pagan religions are religions who are not yet completely civilized. They call us as people who are not completely civilized. They do not have a particular profound literature as that of either Bible or Quran or Old or New Testament. And they practice according to a particular way of life. They worship the nature. They worship the fire. Whatever they find in the nature, they would go and worship. So they are all called as pagan. They make an idol and they are idolatry worshippers. So they are all called as pagan religions. Pagan religions is what they refer to for Hindus or for Jains or for Buddhists and other religions that we see. Now, we see, before I speak on some of the tenets of Islamic law, because the Islam rule happened in India, a brief geographical outlook on what had happened around the world at that particular point of time would have to be seen. Somewhere around 6th century is when the Prophet was seen, Prophet Muhammad. His lifetime was around 6th, 7th century. As we all know, Christianity was born in the 1st century. And after about 300-400 years, by 5th or 6th century, Christianity was also on the rise. and by 6th century or 7th century, Islam had also begun. So there were a inherent zest in both these religions in order to occupy the territory. Now, if you either have a very cursory look at Quran or the cursory look more so with the New Testament than the Old Testament, you would know that both these religious scriptures are quite predatory in nature. That is, it cannot exist along with the order of coexistence with other religion. They would say that a non-believer should not be spared. Non-believer will have to be converted into a believer. What are the modes of converting into a believer is for later to see. There are even aspects covered in Quran and Bible for it. But they say that our religion is the best, and according to these particular scriptures, that may be Bible or the Quran, non-believers will have to be treated in a particular way, believers will have to be treated in a particular way, and for that to function, it is very, very important for them to rule. So without a political rule in the hands of either in the hands of Islam or in the hands of Christians, it was very difficult for these two religions to spread its thought process by mere exposition of their philosophy. Which ruler, if you look into our own country here, more or less around the same time when Prophet Muhammad was born, Shankaracharya also existed in India. Look at Shankaracharya, his exposition of Vedanta have been accepted almost by everybody in country. There are two other sects of Madhva and Vishishtadvaita that we see, Dvaita and Vishishtadvaita. But the people following Dvaita, Vishishtadvaita are comparatively very, very minority in number. I'm only on the volume, not on the quality of anyone. I'm not speaking on either Dvaita, Advaita, Vishishtadvaita here. The number of persons who follow Advaita, it can be Sthula Advaita or it can be the actual Advaita, what we call as the science of reality. Many people follow Shankaradvaita here, starting from Kashmir to Kanyakumari. Which ruler endorsed Shankara? Or which ruler did Shankara have to fall on in order to espouse his philosophy of Advaita Vedanta? All he had to do is very, very be objective in his analysis and had to shaft the grain from the rice. And if there is real sattva in a particular philosophy, it would automatically follow. Whereas in complete contrast, we see in the Middle East that after the life of Prophet, what was his, of course, we call Quran as the sacred text which the angel Gabriel informed Prophet Muhammad, and by virtue of which Quran was formed. Then the life and actions of Prophet Muhammad was later recorded by his immediate followers who had direct access to him, and they were able to live with Prophet Muhammad and say this is how his actions was, this is what he had said, and all those were documented together as the hadiths. Now these Quran, hadith and ijma is the common consensus. These three form the primary sources of Islamic law or the Sharia. The Sharia consists of these three primary sources. There are a lot of other secondary sources. So if one would have to know what is the primary source of Quran, you would have to look into these three. Now these three, for it to function, we see that geographically what happened was after the death of Prophet Muhammad in 632 AD, within a span of about 1 century, in 100 years, the Islamic rule spread like a wildfire, like a forest fire everywhere. We see that by the end of Prophet Muhammad, the central Arab part where we today have Mecca, Medina and some certain surrounding areas were where Islamic rule was there. Then by about for about 50 years or so, they first took the entire Arabian Peninsula, that is Saudi, Yemen, Kuwait, all of these peninsula that we see in Saudi Arabia were taken over by Islamic conquest. Islamic rule was there. Then they slowly moved down to Egypt. Then after having completely secured Egypt, they within 6 months Syria fell to Islamic rulers. Syria also went away. Then Iraq and Persia, which is now called as Iran, Iraq and Iran also fell. Parts of Afghanistan also fell. Then later Libya, and after Libya, Morocco, and by around 732 AD or so, they even could capture Spain. So if you look at it, around the Mediterranean Sea, starting from Arab until the southern part of Europe where Egypt and all of these places existed, the Islamic invasion ran and they conquered all these places. And within 100 years, Islamic rule was there in this part. In and around the same part, there was Christian rule, which was also running and also spreading. We all know about the caliphate who was there here, and Constantine, who had to change from the Roman from the Roman law. He had to say that everybody had to become Christians. Until one day before, those who had embraced Christianity would be prosecuted, and one day later, those who were not Christians had to be prosecuted. This was the effect of Constantine embracing Christianity. And then Constantine's son again went back to the Roman religion. Then his grandson again came back to Christianity. And we see several of these after initial hiccups of Christianity. Then Christianity overtook the entire Roman Empire. By then, Roman Empire was by far the farthest, the greatest empire to be formed in the European region. Then automatically Christianity also flowed to various other parts of Europe. Automatically there was a great resistance for Islam to flow into Europe in view of the Christian domination at that point of time. Then why did it not flow the way it fell all over to Morocco, Spain, etc.? Why did it not come to India? Is a obvious question that we may ask. At that point of time, India was considered to be one of the greatest empire. Although there were too many small empires that we would see, it offered a great resistance for these Islamic rulers to come. A king who perhaps nobody would even remember in history, his name is Chacharai of Chittor. He had defeated the Rana of Chittor and he had acceded to the throne. He was a Brahmin by caste, and it was a Brahmin who was ruling the Chittor. His name was Chacharai. In about 630 AD itself, when the Islamic rulers tried to invade into India, this man Chacharai was able to defeat them and send them back. They again tried to come again for a period of 40-50 years. Every time they came, they had to be defeated. Then a spy was also sent to see if what should be there in order to defeat these Indian kings. He went back and he said, he is a very stiff-necked and a hard-headed fellow. There is no way you can get into this particular province. So leave your ambition of getting into this particular part of the world. Let us go and take other parts of the world. And therefore, India had stopped at one of the initial invasions that had happened in the mid 7th century AD itself. Then there was Muslims trying to take over the French dominated part of it. There was a king there called as Charles Martel, who fought very bravely and sent back the Islamic rulers. So therefore they had to be content with this. Then in about 713 AD or so, we see Muhammad bin Qasim, who comes into India. He for the first time takes over majority part of Afghanistan. He even comes and attacks Sindh, and after a long battle kills Raja Dahir. And then shortly thereafter again Hindus come back and take over Sindh. Sindh entirely is taken except for two small cities. One is Mansura and another is Multan. They could have also taken away Multan. The story goes that when Hindu kings went to acquire even Multan, the original name of Multan is Mulasthana. And there was a sun temple in Multan which was very, very famous. We had Konark Sun Temple to the west. We had Mulasthana Sun Temple to the east. And after having lost Mulasthana for a very long time, then came Modhera much later. So we have sun temples to the east also, which was Mulasthana. That particular sun temple had the sun god, Vigraha there. They took it to the battlefield and they said, if you come and attack Multan, we would destroy this particular idol. So these God-fearing kings, they were very, very, they thought it is important that the idol should be protected. So they saved the from attacking Multan, and they left it to them. So, except for these two cities, everything else as part of the Sindh again continued to be in the hands of Hindus. Then Muhammad bin Qasim could only take parts of Sindh and Kashmir, and he couldn't take or even cross Rajasthan at all. Even his own accounts, which is recorded in various books of Sitaram Goel and various other scholars, they say that even he did not mention for having come to Malwa region, Mawar region, or taking or crossing Rajasthan at all. So he was content at coming and taking certain parts of Sindh and going back. Then again, there is a story that he was called back, but in this particular campaign of Muhammad bin Qasim, he lost lot of men and military. Lot of finance was lost. So therefore, story goes that he was again called back and executed. Be that as it may. Then the next invasion that we see is of Muhammad Ghazni, followed by Muhammad Ghori. Ghazni or Ghori, although they had invaded India, they had looted India, they had looted several temples, destroyed certain temples, taken, looted, and gone away. We did not see that they came and ruled India at all. They were not ruling. And when we talk of law, only when a person administers a particular region will he make a law. When somebody was not administering, they were only coming and looting, what law would apply to any of the citizens by them? So Islamic law was again not applicable at all despite all these Islamic invasions. So it's only in the political history. Then we see for the first time Qutbuddin Aibak, who comes around 1206. He ascends to the throne of Delhi. He becomes then the Delhi Sultanate follows. Then there is Iltutmish. But until almost Iltutmish, we would have to see one other interesting aspect, that all these kings who invaded India, who also came in, they had their mother power in Saudi Arabia. So the kings at the Saudi Arabia or the caliphate, we all know about the several caliphates who were ruling. So this Uman caliphate, etc., they used to order and say, you do this. Suppose there is a particular antisocial element, a rowdy. You tell him, you go and beat up so and so people in this particular area, I'll give that area to you. You would be more than happy to go and beat up. Similarly, some of these people were also sent to several regions to go and acquire, and if military campaign was successful, they would be held there. But they were allied to that particular caliphate. They had to pay all the taxes, send all the treasures, etc. there, and had to act according to their rulings. And whatever high command used to come from Saudi Arabia had to be followed here. That was the rule. But then what happens? Mongol raids come in. Mongols raid. You're all aware of Genghis Khan and his grandson. He had sent two of his emissaries. They were killed by the caliphate. He sent two more emissaries. They were also killed. Because of the ambassadors being killed, he got enraged and he started a raid. And he was a very, very ambitious ruler also. So he started coming and hitting out everybody. And he had taken over even a part of Arab, almost till Baghdad. He had made invasion, and Mongols had taken over almost till Baghdad. But as fate would have had it, his religious leader way back in the central province of Mongolia, he died, and he got the news that my guru has died. So he went back, leaving this particular invasion. So we see that Mongols, although came, and they are considered to be very, very barbaric, they are very, very what we speak of several barbaric kings here. The Saudi Arabian kings and the kings in Afghanistan used to say that most barbaric is Genghis Khan and his entire that Khan family. And Genghis Khan was not a Muslim. He belonged to the Mongol tribe. It was much later that in Samarkand and all these places that the Islamic rule had followed, they converted several Mongols to Islam later. And that is how the surname Khan, which is originally not an Islam surname, later on became part of an Islamic surname. Wherever you hear the word Khan, it was basically from Mongols, and they belonged to a particular tribe. And when during his invasion, he was a Buddhist tribe, to be very precise. And during his invasion in this Silk route, which flows through Ladakh, Kashmir in the present day, he also wanted to invade India. But he saw that single-horned dinosaur, which was one of the sculptures that is being made by the Buddhists as a part of their symbol. He saw that, oh, it's a very, very sacred land because there is a Buddhist tribe and I should not invade this particular land. So he left this particular and he went ahead and went till Baghdad and he came back. Now, after this Mongol raid, the caliphate who was running this entire show or who held the supreme power of all Islamic rulers himself was cut to size, and he was unable to put all kind of or exercise the entire power all throughout several of his so-called Samant Rajas who were there in India or other countries. As a result of that, these people became independent. So we see that after the Mongol raids and after this Uktai was also lost to Mongol Khanate in 1229, then we see a Turkish ruler Balban coming and taking it over. And after the death of Balban, again there was a resurgence of Hindu rule, and again Hindus came and acquired the entire territory. Then Hindu power was revived. Then much later we see Jalaluddin Firoz Shah coming from Afghanistan, and later Alauddin Khilji coming. And when Alauddin Khilji along with Malik Kafur came, it is for the first time that we see an Islamic invasion not only in the northern India, that it goes down almost till south, until Tamil Nadu, Warangal, even all these places, there was an Islamic invasion by Alauddin Khilji. And again, there was a closure of Khilji dynasty, then came the Tughlaq dynasty, we had Ghiyazuddin Tughlaq, Muhammad bin Tughlaq, then Firoz Shah Tughlaq, and thereafter there was a closure of even of the Tughlaq dynasty. Then came a small invasion by Taimur, and after the Taimur invasion, these Sayyadis and Lodhis, they again came back to power. And after Sayyadis and Lodhis came back to power, in the south at the relevant point of time, Bahmani kingdom was also formed. Then we have the Shahs coming to power, that is Muzaffar Shah, Ahmad Shah, etc. And all of these people were all from the Afghanistan region. Then we see that in about 14th, 15th century, 16th century, Babur comes back. He is again from the Turkish side. So there is always a fight even among the Islamic rulers. Either they are from the Afghan side or they are from the Turkey side. They fight with each other and they try to form a rule here. And the Mughal Empire, we all know about Babur, Humayun, Akbar, so on till Aurangzeb. Now, if you look at this entire Mughal or the Islam period that was in force, it is from 12th century when Qutbuddin Aibak actually came. Although invasions had happened, the administration of Islam happened from 12th century until almost the 17th century when Aurangzeb died. With the death of Aurangzeb, the Islamic role had almost come to an end. Although he had his successors, etc., they were only there as a formal rule. A particular person was put, and then after the death of Aurangzeb, we see a very huge rise in the Maratha power, and the Marathas in the form of Peshwas, etc., ruled almost 80% of the territory of India. And after Marathas, we see the Britishers coming in. Now we will look at the law that happened during this 12th to 17th century. It is very interesting firstly to note that even in these 500 years, despite Islamic rule, not even once did any Muslim rule over the entire country of India. They acquired different portions of India, different kingdoms of India. Several kingdoms of India fell to Islamic invasion, but after a particular point of time, some other Hindu king would come, he would again revive, they would go. So at no point of time did we see that the entire India was under Islamic rule at all. And even when the Marathas came back to power, for the first time we saw that a Hindu kingdom having such a large territory under its administration. But they again could not hold that particular kingdom for very, very, very long time. And as these people were expanding, by 13th, 14th century, we also see the rise of Vijayanagar kingdom here in the south. And before that, by about 3-4 centuries earlier itself, we see the great Chola dynasty which was here. It can be the Rajaraja Chola, Rajendra Chola and Rajaraja Chola too. While these people were trying to make attempts to come into India, the Chola dynasty, the three main exponents of Chola dynasty, Rajaraja Chola 1 and 2 and Rajendra Chola, had not only acquired a great part of southern India, but they had expanded their kingdom to southeastern countries
of say Philippines, Indonesia, Malaysia, all of these by maritime expansion, most of these were also taken. And during this 500-year rule, we see that Islamic law were made applicable to the subjects. I'll come to the Islamic rule later. But during this particular period, it is interesting to note that in 14th century, when there is a huge Islamic invention going on there, around 12th, 13th century is where these main Dharmashastra Karas like Vignaneshwara who is from Karnataka, and Jimut Vahana for Bengal were the Dharmashastra Karas. So there was invasion going on, and these Dharmashastra Karas were extremely scholarly. And if you were to name one of the 5 best Dharmashastras, certainly this Mitakshara school and Dayabhaga school would come into picture. Even to this day, our Hindu law is based out of Mitakshara law and Dayabhaga law. Dayabhaga is applicable only to the Bengal region. Rest of India is completely under Mitakshara school of law. The way our father, Kopa, Sundry right, joint family property, daughters having a right, not having a right, all of these are all covered from the Mitakshara school of law. It only got codified in 1950s. I'll come to it tomorrow. These people were busy writing Dharmashastras to greater detail on certain chapters of Vyavahara. We don't find even an astray reference to forceful conversion. What if the ruler happens to be of a different religion? What if he is forcing his religion onto his subjects? What if that particular religion does not assimilate well with our Sanatana Dharma? What needs to be done? None of these Dharmashastra Karas appear to have been written. After writing the entire sources of Dharmashastra, Dr. P.V. Kane in his conclusion fantastically writes these words. In the foregoing pages, most of the classical works and most prominent writers on Dharmashastra during a period of about 25 centuries have been passed in review. The number of authors and works on Dharmashastra is legion. All these numberless authors and works were actuated by the most laudable motives of regulating the Aryan society in all matters, civil, religious, and moral, and of securing for the members of that society happiness in this world and the next. They laid the greatest emphasis on the duties of every man as a member of the whole Aryan society, as a member of the particular class to which he belonged, and very little emphasis on the privileges of men. They created great solidarity and cohesion among the several classes of Aryan society in India, and in spite of their conflicting interests and inclinations, and enabled Hindu society to hold its own against successive aggressions of foreign invaders. They preserved Hindu culture and literature in the midst of alien cultures, and in spite of bigoted foreign domination. There is no doubt that the authors on Dharmashastra, in their desire to evolve order out of chaos and to adjust and harmonize the varying practices of people with the dicta of the ancient sages, were guilty of the faults of raising hair-splitting arguments, divisions and subdivisions, and also of thinking that religious rites and formularies were all the be-all and end-all of human existence. But living as most of the latter writers did in the midst of aggressive and violently unsympathetic cultures and rulers, and possessing no powerful central government that sympathized with their ideals, they were driven more and more to revolve within their own narrow grooves, and could not see far in order to regulate society in a free and buoyant spirit. In spite of these defects, the work done by the writers on Dharmashastra should excite our admiration and entitles them to the regard of all those that are interested in the study of vicissitudes of Hindu society for thousands of years. So this inference by Dr. Kane very clearly shows that several of these Dharmashastra Karas, even while writing the Dharmashastras during the invasion period, hardly had much to say about the onslaught of invasion and how to defend themselves and to make a law pertaining to it. There was no law given to a duty of because they believed perhaps that the king already had a duty to protect his subjects. The king already had a duty under the Dharmashastra to stop any foreign invasion from happening. But they did not differentiate any neighbor foreign invasion from an invasion of a particular Semitic religion. These kind of differences we see do not exist in the Dharmashastras. If this is to literature, even politically speaking also, R.C. Majumdar in his book of History and Culture of Indian People writes this. Al-Biruni, who flourished at the very beginning of that period, that is the 10th century, tersely but very correctly observed. The Hindus entirely differ from us in every respect. It is Alberuni's context of what Hindus are. We don't see a corresponding spirit being written by any of the Dharma Shastras here, but look at their analysis of us. They say the Hindus entirely differ from us in every respect. We believe in nothing in which they believe and vice versa. Then Narasimharaja writes, this radical difference in religion and social usages and customs operated as an almost insurmountable barrier between the two, which even 900 years residence as close neighbors failed to break down. Henceforth, this difference constitutes the underlying thread which wove the Indian history into an altogether new pattern. And he says how the history has completely molded in a very, very different fashion from 12th century onwards. The introduction of Islam and its existence as a separate unit in India introduced for the first time the generic name Hindu. He says the word Hindu was coined by Islamic rulers when they came in here during the 10th, 11th century. Until then, we did not know of a term called Hindu. Now, what is Hindu? Hindu is originally a Sanskrit word called Sindhu, Sindhu Janaha. Sindhu means those who live by the water. It can be the sea or it can be the several rivers through which we all live here. If you look at it, we have 7 sacred rivers in India, and it is a peninsula. We all live by the coastal region. So therefore, we are all called as Sindhu Janaha, those who live by the sea and by the rivers. And you had the very famous Sindh Pranta, the Sindh province which was there. So the people who existed in that particular region were called as Sindhu Janaha. And when you look at Prakrit from Sanskrit, when the language shifts to Prakrit, Sa becomes Ha, Saptaha becomes Haftaha, in Prakrita it becomes Hafta in Hindi, which is 7-day a week, which is called as Saptaha there, becomes Hafta in Hindi. So Sa becomes Ha in Prakrit, and this is how Sindhu became Hindu. And therefore, the very term, coinage of the term Hindu only denotes we are region specific. This is to say who are Indians as to how they gave the word Hindu. And it is not because we worship a particular god or so we are called as Hindus at all. And what I am saying now has also been said by several other authors. It has also come through the judgments of Supreme Court. So I don't have to doubt that the word Hindu is not to any religious denomination at all. It is only region specific. And R.C. Majumdar also says that it is these people, for them we were all kafirs. One who does not believe in Islam were all called as kafirs, or otherwise called as infidels. And they said whoever is an infidel or a kafir would have to be conquered. And therefore you conquer this people of India, and as a separate unit you will have to be distinct from them. And therefore they say it bore the same connotation as the term non-Mohammedan used in Indian constitution during the last days of British rule, and the use of the term Hindu in a narrower sense to denote the followers of Orthodox Brahminical faith belongs to a much later date. So to say what is Hindus are only these people who have so and so religious, certain religious etc. were only invented by recent scholars in order to paint a history completely differently and give a different color to our historical reading. And the way Kane observes by reading the Dharma Shastras, look at how historian R.C. Majumdar also observes. It appears to us as passing strange that India, south of Vindhya, seems to have lived in a world apart from the rest of the country. Undisturbed by the ominous tidings of Muslim aggression, the ruling powers in the Deccan and South India were as busy as before with their petty domestic quarrels and dissensions and military campaigns of aggrandizement against one another. During the 100 years that kept the Muslims fully engaged in consolidating their powers in the north, the south went on in fancied security as if nothing had occurred to disturb its equanimity or threaten the continuity of its history and culture. So little was the Muslim danger thought of, even in the region immediately to the south of Vindhyas, that the powerful Yadava rulers of the Deccan attacked from the south of Chalukyas of Gujarat at the very moment when they were engaged in a life and death struggle with the Muslim invaders from the north. So Yadavas are fighting from the north, from the Muslim, they come and attack southern Hindu king in order to consolidate more power. Such incidents give a rude shock to the idea of fundamental unity of India. And then he says, although this period dealt with in this particular of 3-4 centuries is one of decline and decadence of the fundamental unity of the Hindu rule in India, it serves a very useful purpose in the history study of Indian history. it holds out before us a complete picture of Indian culture and civilization just before it came into contact with Islam. If we compare it with the culture of Hindus before the impact of Western influence gave it a new character, we can form a reasonable idea of the extent to which it had been influenced by Islam. Such a comparison alone would enable us to answer the question whether there is any such thing in the present day India which we may regard as Hindu culture, or the present day culture which should more probably called as Indian culture, which is neither Hindu nor Muslim, but a composite of both. As to what the present scholars denote, but he says the Muslims generally are under no illusion in this respect, and they speak of Islamic culture in India as a distinct entity separate from Hindu culture. It is only Hindus who think Indian culture is Islam plus Hindu culture. Muslims never have this doubt. They say if you talk something as an Indian culture, we think it is only Hindu culture. For us, Muslim culture is distinct and it is separate from your Hindu or Indian culture at all. And it is for Hindus to judge in a dispassionate manner, free from prejudice or conventions engendered by recent politics, how far from the main aspects of Hindu culture, that is, namely, religion and philosophy, social conditions, art, language, literature, law, and legal institutions, as described here, were left intact at the end of Muslim rule. So, what had earlier happened and how it later was it intact even during a particular rule or not, is for you to assess, is what Majumdar says. We have had rulers of Jainism earlier, we have had Buddhist rulers come here. Even before their rule or after their rule, nothing happened to the law of the land, it had remained intact. But when we look at the Sharia laws, look at it, the main Sharia law is based on, as I told you, three things. One is the Quran. They say whatever was written in Quran is a clear injunction of the holy book, and it has an overriding authority on every other aspect. If Quran says something, and if any other thing says something, they don't care what the text is, Quran shall prevail. That is the first primary source. Followed by it once again as a primary source, but second in leg, is the hadiths or the traditions of the Prophet. They hold that Prophet was the best interpreter of the revelation contained in Quran. Who could interpret Quran? Prophet is the best interpreter, and therefore his saying and actions are considered to be of vital importance. They say if something is only in writing, this was according to me in terms of law a master stroke, because if something is there in particular law and say some part of it is vague and it could be interpreted this way or that way, generally by flow of time, however one would have a particular facts or a scenario before them, they would alter the course of what is strictly written there in order to mean something or the other. Therefore, even in our own scriptures of Dharma Shastras, what is an Apad Dharma perhaps 200 years back may not be the Apad Dharma today, it changes. So, we tend to see the social change as well as the legal change very continuously. But in order to ensure that such social changes do not happen there, they said whatever may be written in Quran is not left for you to interpret. It is for you to interpret in the light of the actions of life of Prophet. If Prophet has lived in a particular way, Quran would have to be interpreted only in that particular way, is what the Hadith says. And going by that particular saying and actions, they form even more important to see as to what the Islamic rule is. Then Muslim scholars have also developed an entire science of shifting trustworthy traditions from which are considered to be forged or unreliable. What is trustworthy, what is not, this has also happened. Then Ijma is nothing but consensus of opinion. And where there is legal opinion is unanimous regarding interpretation, they take it. If it is not considered to be unanimous, they just go by whatever is there in Quran or Hadith and they take it. Then they say, we again have even under the Quran and the Hadith put together are called as the Sunnah for Islamic law. Now under the Sunnahs there are 4 schools of thought, that is Hanbali, Maliki, Shafi and Hanafi. These are the 4 schools of thought. Now out of these, the last 2, that is Shafi and Hanafi, have gained much more greater popularity. The first 2, that is Hanbali and Maliki, are more fundamentalist in nature, and Hanafi school gives a much greater importance to rational deduction than any other school. Comparative between the 4, Hanafi is more rational, and therefore the Hanafi school was again strengthened by Imam Abu Hanifa and Imam Abu Yusuf, etc., and they gave. But if you look at the law as to how they were applying to non-Muslims, they used to say that every Muslim, it is important that he pays tax in order to feed the poor. But if you are a non-Muslim, the best thing for you is to convert and accept Islam. If you cannot accept Islam at all, and if you continue to be in your own religion, then just because you are rebelling from that particular religion and you are staying there, therefore you will have to pay a separate tax called as jizya. Now, how do I know that you are not a follower of Islam? If you go to temple, pay jizya. If you do a particular business and you have to pay tax, and if you happen to be a non-Muslim, pay jizya. If you go on a pilgrimage, pay jizya. So wherever other religions, it need not be only Hindus, any non-believer of Islam had to pay this. And they also had second aspect, one more called as zimmi. They said zimmis are also people who are protected under the Islamic rule by the Islamic rulers without conversion. They can come under the Muslim fold, be entitled to certain benefits, but the Muslim rulers would accept that they don't really have to convert, but still give them certain benefits, and so on and so forth. They gave certain concessions to them. But by the end of it, we see that wherever the Islamic rule was at the highest or at the peak, say for example Delhi for instance, in none of these places people were able to follow either the aspects of achara or even vyavahara for that matter by the end of the Sultanate or even the Mughal period. They all had to be governed there. The king was the ultimate head of the judicial authority. He had two faces. One was, he was called as the Diwani Kaza, that is arbiter of disputes. He is the supreme judicial power. Then he was also called as the Diwani Mazalim, same person wearing two hats. Diwani Mazalim is the bureaucratic head, the administrative head, as well as the military head. Then below Diwani Kaza, there was the king, would be Diwani Sisayat, which was governed by lawyers and inquirers. They were forming Diwani Sisayat. They would also adjudicate some of the major disputes. But for all these contractual disputes, etc., Qazi Mumalik, there would be a Qazi at every district place or a taluka place, etc., who would be the final authority on various of these civil and criminal litigations. So until the advent of British and after the Renaissance period, what we see is either under the Islamic law that ruled our country or even under the Dharma Shastras, the religious text is what we call as the basis of which we were doing, basically went into every aspect of law. Dharma Shastras was not restricting itself only to achara or how you are supposed to do worship, how you are supposed to worship, how a temple should be built. No, it went into even secular aspects. The way they could enter into secular aspects was because secular sciences and some of the core aspects of Vedanta actually cannot differ from each other. It is nothing but realism, and it had to assimilate itself and stay. Then after the Islamic period was over, we see the Marathas being there, and with the advent of Marathas, again the courts, etc., all of these also changed. The Islamic rulers also changed several manner in which we were even doing day-to-day trades and transactions. For example, even to this day, when you look at your record of rights for your agricultural properties or pahnis, you would find, if I am the owner, they would write Kashyap bin Narahari. That Kashyap bin Narahari means Kashyap son of Narahari. It is the same bin, Muhammad Osama bin Laden, that bin is son of. So it is a Arabic word which is used here. So the word khata, all of you use for your property, is also an Arabic word. Then you would have heard of Akar Band. All of these revenue entries that we speak of on a day-to-day basis were all inclusions even in the documentations, etc., by Islamic rulers. It was Tipu who brought all this here in Karnataka for that matter. Other places, of course, the Islamic rulers also brought. Anyway, then after that we see the advent of British. Now, when you look at Bible, you had two aspects of it. One is the Old Testament, another is the New Testament. One who follow the Old Testament, you have Judaism. Then the New Testament, you have Christians. Then uh, by the time the Britishers set their foot here, and by the time they actually took power from the Marathas, and they were able to rule our entire country, by that time we should not forget that the Renaissance period in Europe was at its peak, or perhaps at the closing stage. Now, until the Renaissance period, there was no difference between church and state. That is, whatever the Pope had to say, whatever the church would say, that would become the law. Therefore, you have story of Galileo and all those people where if they said that land is straight, it has to be straight because Bible has said it is straight. Even if you, by scientific methodology, if you show that it is round, they will say no, 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 it is flat because it is said in Bible. So on and so forth. Every aspects of Bible had to be taken in its entirety to letter and spirit, more than spirit to its letter, and to be believed. This was how the church made a law was in power in Europe for a very, very long time. Then there was revolution, and then they changed, and you have the French Revolution, you have the Renaissance period. And after the end of Renaissance period, they said that church and state shall be separate. The political administration of how we run our government will not be guided by the church. How we have to lead our life in a particular way, how we would have to worship, and about laws pertaining to marriage, on how we should marry, all of this would be covered by what the church says. And by then there was already Roman Catholic, Protestants, etc. And to the extent of the church that you would go, you would do. Other than that, everything else would have to be followed by common administration. Now, how did they get this concept of common administration? Even before Christianity had set its foot, there was a long history of Romans and Greeks. If you look at the famous book of Will Durant on story of civilization, you would know what an amount of several laws and the manner in which it had to be functioned was all told by the Greek and the Roman kings. Roman law is quite famous. The present day law which we all follow is mostly British made law, and what the Britishers follow is mostly Roman made law. So therefore, Roman law on administration, Roman law on several of these adjudication of disputes, and on several secular aspects were all to be covered. So they said, you don't have to worship Zeus, that's okay, the church will take care of it. But as far as following a particular procedure of either courts or the law, etc., go by how generally the Roman law would be there, and therefore the difference between church and state came into picture. And then there was legislative authority, parliament, how it would be made, etc. They copied, or more than say copied, they were influenced greatly by the democratic manner in which the Romans also used to function, and the similar kind of administration and administration of justice both came into picture in Europe. By the time it had already set its foot there, thereafter Britishers entered. That is the reason India did not have to face the canonical rules which are specified under Bible and fight against it, because thanks to the Renaissance period, the church and state was already separated by the time Britishers set its foot in India, and therefore we only had to think more about the administrative malpractices, corruption, etc. more that British had to do. But did the British stop at it and say, okay, we are only to do with the administration, we are only to do with state, etc. So I will not worry about converting these people, we will not worry about what religion they follow, we are only interested in money, anyway we have come here to loot, let us loot and go. No. Not much of literature is available on several laws that they made in order to oppress the native religion of India. But if you just have a cursory glance of the history, at the end of 18th century, that is in 1780 or so, in Bengal we see that there was a Sannyasi rebellion. This Sannyasi rebellion which started in Bengal had gained momentum and it even come to Bihar, and later they merged with the Marathas subsequently. This Sannyasi rebellion was so big that the East India Company had to deploy a person called Captain Edwards to fight these sannyasis. 300 of British soldiers were killed, and Captain Edwards lost, and he was moved back. And with great force, Britishers had to stop the sannyasi rebellions. Now ask yourself as to why would sannyasis go and fight if Britishers were doing some malpractices, only doing corruption, taking some money and going. What has sannyasi got to do with all of this? That too, sannyasi in India. How about how the East India Company is functioning? Unless and until it hits the very religious practice or the manner of their life, way of life of a sannyasi, which is one of the core aspects of how he would want to function, why would they go on a rebellion? So we know by some of these rebellions that they did make several of government orders, or it can be several orders being issued, etc., in which the native religion of both Hindus and Muslims were tried to be snubbed. Then we see that by 1857 there was a huge uprising, and we see the first war of Indian independence. Now the first war of Indian independence, many people try to call it as a mutiny and so on and so forth. Before that, the doctrine of lapse had happened. Now the doctrine of lapse, it is a very basic connotation under the Dharma Shastras here, that after the father, the son would come to rule, and if the property belongs to the father, property would also come to the son. Now administration of justice is one aspect, holding property rights is another aspect. The king, by virtue of his being the ultimate authority of that particular region, apart from holding the administrative head, would also be owning certain property. Now, if Britishers wanted to take the authority, they could have taken. How would you go and say that your property also belongs to me because I've taken over the authority? It is two different things. Property right of a king and the administrative authority of a king. So they made this doctrine of lapse, by virtue of which they said you cannot adopt. Adoption is recognized under Hindu law for a very, very long time. In most of the Dharma Shastras we see this. They said we don't recognize adoption. If you adopt somebody, and by virtue of that adoption, if he were to become the heir of you, then we will not consider. Only if you have your own heir, then we will see that it flows to you. If it does not flow directly to you, and by virtue of adopted son, we don't recognize the adoption, and then your entire estate along with the property flows to us. So they started usurping the lands as well as the rulership of several of these kings, and they tried to take. This irritated the minds of Indian people to a great extent. Then they did not stop at it. They made several laws on Hindu endowments. In fact, the earliest law was sometimes seen in the end of 19th century itself. Later on, even under the Mysore region, we see Mysore Religious and Charitable Institutions Act of 1927. I'll come to it after East India Company goes. But nevertheless, before the statutes were made applicable, we all know about the gun which had to be taken out by biting it. The bullets would have to be bit, cartridge would have to be taken by biting it, and that cartridge was filled with coats of meat of the cow as well as pig, which are both not acceptable to Hindus and Muslims. So therefore there was a religious outrage. And if this was the only religious outrage, only Sipai mutiny would have happened. Not every other region and other kings would have not joined hands in this. What had Jhansi Rani Lakshmibai got to do with the cartridge being taken off? So the entire religion of the native religion of the people, the way in which they were leading their particular life, was also equally snubbed very greatly by British. As a result of this, 1857 war of uprising happens. How do we even know this? Is because the very first sentence of the Queen's proclamation, East India Company went away after this particular war, and Queen proclaimed like an apologetic note and said, sorry, this particular thing happened to all you people. From now on, British government directly will take over, and we will ensure that you are all ruled properly. What is the first sentence of the Queen's proclamation? The first sentence is that the British government shall not interfere in the religious affairs of India. So we know that it was mainly due to the religious affairs which had prompted even a layman and a common man to go on an uprising in the 1857 war. And after the Queen's proclamation, several laws, the common law code was made applicable. the statutes that were made applicable in the Privy Council by the British Parliament were made applicable to India also. Then came one more interesting contradictions here. That is, one, legislated laws of the British government on one hand, and our personal laws, the Dharma Shastras, on the other hand. British coined a term called the personal law. They said, here are several people here, one practices Sikhs, one person practices Jainism, Buddhism, Hinduism, so on and so forth, and you all have your own manner in which the property will have to be inherited, your marriage, etc. So as regards your inheritance of property, and as regards your aspects on marriage and your adoption, etc., we would call it as personal law, and we'd leave it to you, the way in which you would want to deal with it. So therefore adoption, all of this came into our fold. They said, you follow your Dharma Shastras whichever you want and you go by it. But as far as all other secular aspects that were covered in the Dharma Shastras, mainly the chapters on Vyavahara, which had the highest corpus of Dharma Shastra. When you compare Achara and Vyavahara is much more in number, in terms of weight when compared to the texts on Achara at least. So this entire chapter on Vyavahara, they said, will go by the British made Parliament. So therefore, all our Dharma Shastras after the British rule came down to mean only for laws pertaining to marriage, inheritance, etc. and for our worship, our temples, etc. and they went on. Then what did the Britishers do? Did they say that, okay, you are maintaining your own mutts, temples, etc., we are happy with it? No. They made several laws on endowments, religious endowments. They saw that despite us stealing so much of money from these people in virtue of trade, etc., these people still get some money to go and donate it to temples. They put some of their money to mutts. They are very, very highly religious in nature. So unless and until we tax that particular mutt, the religious institution, temple, and we take out the funds, it is not necessary for us to only go by transaction and collect tax. So they started this Religious and Charitable Institutions Act, and in that there was a term called Muzra Institution. The definition of Muzra Institution is, Muzra Institution means and includes every matha, temple, mosque, other places of worship, religious service, every chhatra or house of feeding or rest for travelers with or without charge, or other institution of religious or charitable nature which is now actually in the sole charge of government, or for the support of which any monthly or annual grant in perpetuity is made from public revenues, or an inam is granted and is recognized and registered as a Devdaya or a Dharmadaya grant. Literally speaking, all the Dharma Sattas, Dharma Chatras, the community halls, the temples, all of this were brought under the definition of Muzra institutions. And all of these Muzra institutions, they said, I am going to appoint something called as the Chief Controlling Authority. I am going to appoint the Deputy Commissioner and Assistant Commissioner and Amaldar at each level. They are supposed to collect from the funds. How much our funds is being donated there will be directly seen by us because government is taking over. So this way, in the British government, the entire funds which was with the temples and various other institutions were taken away, and they had complete access to it. Then taxes are also imposed on several lands, including the Inam lands. Inam lands are those, for example, a priest is doing a puja of a particular temple. He should ensure he continues to do that particular puja. A land is being given to him. Somebody was a divan, or somebody has assisted the Maharaja in so and so, he would be given a particular granted. They are all called as Inam lands. For example, a matha which is being run for you to run a particular matha, a sannyasi is given a granted land. All of these lands also were taxed by the British. There is, in fact, nothing on which tax was not levied by British, including salt, there was heavy tax on it. And by virtue of these taxes, they started taking. And interestingly, look at our own people. There were several reforms being made during the British period until we got independence. You have the Simon Commission, you have Montego Chelmsford reforms, you have Minto Morley reforms and whatnot. In all these reforms, Britishers sent people, representatives, to come and say, okay, there is a freedom struggle going on, all these people want something or the other. We will sit and say, don't fight, what do you want? We will settle at a particular this thing, we will give you what you really want. You want representation, you want that, you want this, and they would negotiate and they would give. This is basically all these reforms. In none of these reforms, none of the national leaders, especially after Tilak, have even given a single memorandum to the British government saying, please don't tax temples. Please don't interfere in our religious affairs. These are all the laws which are affecting our day-to-day religion. So therefore, you stop your hands from doing all of these. Give us our complete independence for the mathas, mathadipatis, for religious institutions, charitable endowments. None of a memorandum has also been submitted to them. They were more interested in certain administrative powers. We should stand for election. Indians should also be able to represent our power herein. What they are supposed to do. Where is the representation? Many of these we see. But nowhere do we see a single national leader of our own country going and submitting to British that you are affecting our religion in this particular manner and that you need to give it back to us. No such memorandums can be seen. Then, of course, they also knew the divide between Hindus and Muslims, and they used it as a powerful tool to divide and rule. And then we also have just before independence, the claim made by the Muslim League to have a separate country, and Pakistan was formed. In the entire world history, there is not a single country apart from India which was partitioned only on grounds of religion. It was only India which had to lose a great portion of its land by virtue of only on the grounds of religion. And perhaps this was a clash and a disturbance of religion for time immemorial, which ultimately saturated and came. But the law pertaining to transfer of power, even at the time of the manner in which the British handled, is very, very unfortunate to the country. How religion played a very important role in dividing these two countries, and how subsequently, even after independence, we failed to understand these very divide between the two main religions in our country and continue with changing or adopting that particular laws will be seen tomorrow. Thank you.